Okay. Hello, everybody. I think we're live now. Just kind of let me know in the chat if you can see us and hear us okay. Gonna take a few seconds, let everybody roll in. Okay, yeah, I think we're all good to go now. So hello, everyone, and thank you for tuning in for our fan game legal Q&A. I have with me today Morris Turek, who's he specializes in trademark law in the US. And also we have Tyler Chou with us from Los Angeles, who's more specialized in copyright law. I'm gonna let them do a proper introduction for themselves, as they can do that much better than I can. So just go ahead, Morris, and then Tyler, go ahead and introduce yourselves.
Thank you, Vince. My name is Morris Turek. I'm a trademark attorney in St. Louis, Missouri. I mostly represent small and startup businesses, entrepreneurs, creators in their trademark matters. So I help them protect their trademarks, search their trademarks, make sure they're available, that there are no conflicts or issues. I also do some litigation at the trademark office when it arises. So pretty much anything transactional related to trademark law. Been doing it for about 20 years, and I'm a solo practitioner, though I do have an associate who works with me who lives across the country in Phoenix, Arizona. So yeah, be happy to answer any questions you have about trademarks.
Okay, and Tyler?
Hi, I'm Tyler Chou, the creator's attorney. Thanks, Vince, for having me, and Morris. I'm so happy to have this conversation with you. I have been an attorney in Hollywood for the last 20 years. I've worked at companies like Disney, Skydance, and BuzzFeed, as well as big law firms. I started my own YouTube channel about 2 years ago and just completely fell in love with the space. I say that I left Hollywood behind because I think it's dying, and I believe YouTube is the new Hollywood. I now represent some of the biggest YouTubers in the world, people like Sam and Colby, Caleb Hammer, Jenny Hoyas, Zoe Unlimited, and I help them build out their media companies. We set up their IP portfolio for an eventual exit and acquisition. I'm actually in the process of selling one of my clients' channels for 8 figures. So realize that you are, as a creator, sitting on something that's more valuable than real estate one day. So I'm really happy to be here. I work on a lot of IP issues, copyright strikes, copyright terminations of channels, demonetizations. So this is what I live and breathe, and I really love protecting creators.
Awesome. Well, thank you both. It's an honor to have you both on this stream. We tried to put this together on short notice, and they're both very busy with their clients and their practices, so it's really hard to kind of sync this up in a short amount of time. And really, the purpose of this stream is because we get a lot of questions from fan game developers, not just with Dark Deception, but with other fandoms like Five Nights at Freddy's and Poppy Playtime 2. And it's always very similar questions about fan game development and using existing assets versus creating their own assets, and trademarking their game's name. Just a lot of different questions that a lot of fan developers are confused about and don't have really any access to legal info about that. But a lot of fans feel very passionate about the game communities that they belong to, and they want to make fan games. So this isn't just covering Dark Deception community and the fan game developers that make Dark Deception fan games. This really applies to all of the YouTube fandoms, which are growing larger and larger every day. And I see a lot of fans becoming more and more involved and jumping into Unreal and jumping into Unity and making their own games. And for the most part, a lot of fan developers are content to just make something for the community and put it out for free. And as long as the developer that owns those assets doesn't have a problem with it, then it's just something that is beneficial to the entire community. But this kind of comes relates more to the situations where what if the developer is not okay with it, or they don't have permission, or they start to believe that they have ownership of these assets. After working on it for so long, people can kind of lose their objectivity of their work and start to think that they own it. Do they really own it, or what is the situation? That's kind of what we're hoping to answer today for all of our fans and the gaming community at large. And we greatly appreciate having your expertise here, because if I answered these questions myself, it obviously wouldn't be something that people could really trust. So I'd rather they hear it straight from the lawyers' mouths. Both of you have decades of experience in law and with the US trademark and copyright legal system. So we're going to go through a list of frequently asked questions and questions that I have been sent by many fans over the last 4 years, numerous times during my Q&A live streams. And after we go through those questions, Morris and Tyler are going to kind of answer the questions that are related to their to what they specialize in. And after that, we'll take questions from the live chat. So if any of you are interested to put a question after hearing the topics that we cover or what we've already discussed, if you have additional questions, we will be able to answer it at that time, and Morris and Tyler will be happy to take it. Just to let you know that this live stream does have a time limit. We are going to do a hard cutoff at 2 hours. They both have to, they have day jobs. They got to get back to work, and we're just happy to have them for the 2 hours. So after that, after they kind of step out, I will stick around and answer any questions you have about. I'm sure some of you are going to try to ask dark deception questions. Save that for after. So I will take those questions after. Okay, we're all cool with that? I think we are. The chat's not. Doesn't seem like they have a problem with it. So I'll go ahead and kick things off with the list of questions that I have here. We're going to start with trademark, because I think most of these questions pertain to copyright. So it's going to keep Tyler a little bit busier. And then Morris is going to address the naming issues that a lot of fans encounter. So one of the frequent questions that we get for trademarks, Morris, is, can I file a trademark for a name for my game that is already trademarked, but by a company in a non-entertainment industry? So if they want to trademark their game's name, somebody already has it, but it's, I don't know, a restaurant or something completely unrelated to entertainment. Can they still trademark that name?
Yeah, it's a good question. Like most things in law, the answer is it depends. In general, you can use and register a trademark that does not cause confusion. So if somebody owns a trademark for XYZ for a restaurant, and you want to use XYZ for a computer or video game, generally speaking, there's probably not confusion. Those products and services are probably not really perceived by most consumers as related or similar, overlapping. And so generally the answer would be yes, but there are exceptions to the rule. If the trademark that's registered is considered a famous trademark, so famous that it's known to most people in the United States or even beyond, then that would prevent or should prevent the registration of the same trademark, even when the products and services are not related or similar or overlapping. That's what we call trademark dilution. Owners of famous trademarks have special protections, and they can basically stop really anyone from using a trademark for any product or service, even when it's not related to the product or service offered by the mark owner.
So for those that don't know, Morris is also the trademark lawyer that worked with me when dealing with Monster Energy and the opposition that they filed against Monsters and Mortals. So that's kind of a good, I guess, comparison is So if something like Monster Energy exists and it's trademarked, they couldn't make a game called Monster Fuel because maybe that's too similar. Or would that have any issues?
Well, it's always hard to say what would happen in any particular case because trademark law is extremely subjective and it's very fact intensive. Um, and also, what one person thinks is confusingly similar, another person might not. And I have plenty of examples in my career where, I have filed a trademark application on behalf of a client. It was examined by a trademark examining attorney at the USPTO. It was rejected. And instead of appealing the decision, because appealing can be expensive and usually your chances of success are not all that great, we just simply withdraw the application and file a new application for the same trademark for the same products or services in the hopes of getting a different examining attorney at the trademark office who might have a different opinion about whether there's a likelihood of confusion. It has happened many times in my career that has worked where we have refiled and it sailed through. So the trademark office, the trademark office is just made up of human beings. They're lawyers. They are lawyers. The people who examine the applications are lawyers, but lawyers see things differently. And you could have one lawyer at the trademark office that thinks there could be confusion, another that doesn't think that there's a confusion. So it's always hard to say what's going to happen in any one case. I will say that I read a blog every morning. It's written by a trademark attorney. Actually, it's written by a patent attorney in Boston, but he loves trademarks. And he writes all about trademarks, and he writes about decisions that are rendered by the trademark office, by the Trademark Trial and Appeal Board, which is a unit of the trademark office. And I'm always surprised about some things that are, that the board rules are confusingly similar, and things where the board rules are not confusingly similar. And there's always comments in the, in the blog article, oh, that's stupid. Oh, I understand that. Oh, I agree with that. Oh, I don't agree with that, because it's so subjective. Like, who knows what's going to happen? So it's an interesting field of law. So it's always hard to say, what the outcome would be in any one case.
I never really thought about that side of it, but you're absolutely right. That brings up the next question, which is how much protection does a trademark actually provide?
Again, it depends. So we have to distinguish between trademark and trademark registration. A trademark is simply a name, a logo, a slogan that is used in connection with the advertising and sale of products or services. So in Vince, in your case, Monsters and Mortals is a trademark for a video game, for a computer game. That's a trademark. Now, the question is, I think what Vince is asking is, what's the value of a trademark registration? Yes. Why would you federally register a trademark with the United States Patent and Trademark Office? And the answer is that it provides you with a lot of benefits and protections that you don't get by not registering. One of the most important protections that you receive by registering a trademark is that you obtain the exclusive nationwide right to use the name in connection with your product or your service. Whereas you may not have those exclusive rights or the nationwide exclusive right to use without that registration. So for example, if you operate a restaurant in New York City, your trademark rights without a trademark registration are going to extend, maybe to New York City, maybe a little bit beyond New York City, but it's not going to extend probably to, Las Vegas, Nevada. With a trademark registration, now your rights in that name extend not just in New York, not just to Las Vegas, but all the way throughout the nation. So that's the value of the trademark registration. It also prevents the use and registration of a similar trademark for similar products or services. So you're kind of reserving the entire nation, when you file a trademark application and achieve a registration.
But that only covers the country that you file it in. It wouldn't cover Europe, for example, or Asia if they file in the US.
That's correct. That's correct. Trademark rights are territorial. And so, you file in the United States. Let's say you obtain a trademark registration in the United States.
Whoa, what happened?
And potentially obtain trademark rights in those countries. Every country has different trademark laws. Many countries are very, very different than the United States. In fact, a lot of countries, trademark rights are based on who filed first, who filed the trademark application first. In the United States, that's not true. In the United States, usually trademark rights are based on who was using the name first, not who filed first. That's a big difference. And the United States the United States is not alone in that position, but we are in the minority in that position. So,
Just to
yeah,
warn you,
it's very very territorial.
for some reason your cam cut off for a few seconds for both of you there. I recovered it, but hopefully that doesn't happen again. We'll see. So they kind of lost some of your wisdom there.
Well,
most of it they got. So
yeah.
just out of fear that that's going to happen again, I'm going to move forward with the next one we have. This is pretty simple. I think you already kind of covered this, which is, do I need to file a trademark for logos and names separately, or does one trademark cover both?
Well, again, there are different ways of doing this. I would say that it is generally better practice to register names and logos separately. The reason is because it's twofold. One is sometimes you're going to use the name without the logo. Sometimes you're going to use the logo without the name. And so having those elements separately registered provides you with broader, more flexible protection. The other reason why it's often good to register names and logos separately is because over time, logos tend to change. And as logos change, you will not be able to maintain and renew your trademark registration if your logo changes. So you'd have to start the whole process again.
Oh.
If you file them separately, then you will always maintain the trademark registration for the name, because names tend not to change. You kind of name something and that's kind of what sticks. And so you'll always be able to maintain that registration and renew that trademark registration over the years. And then if your logo happens to change, then you only have to worry about the logo registration. You could let that logo trademark registration lapse and file a new application for just the logo, the new logo, without affecting your long-standing federal trademark rights that you achieved by registering the name separately.
That's a good idea. So if everybody loves Dark Deception's font right now, but if I went crazy someday and wanted to change it to bubble bobble, like bubble letters for whatever reason, by having it separate, I can change that without just the appearance of the logo, not the actual name itself. So there
Correct.
you go, guys. That's
Correct.
a good thing to keep in mind. If you file a trademark, definitely file it separately, because a lot of you do change your mind a lot. I've seen the fan games constantly changing titles. Don't file them together.
Good advice.
Straight from you. So the next one we have is... let me see. Okay. Am I able to... Oh, this relates to us. Am I able to trademark a game that uses a common word? Example, this is my example, house. How enforceable is that?
Depends. The question is whether the name... It depends on whether the name is descriptive of the game. So if you name your game House, and it actually has to do with houses, then maybe the protection you're going to achieve, the trademark protection you can achieve, is going to be fairly narrow in scope, very limited in scope. But if you're going to name your game House, but it has nothing to do with houses, maybe it has to do with, I don't know, oranges, then that's a very strong trademark, right? Because that name House doesn't describe or suggest anything about the game. So, and that was one of the issues. Do I have your permission to kind of talk about your case?
Yeah, go for it.
With Monster?
They'd
Okay,
like to hear about it.
Yeah, well, that was one of the issues that we brought up in the monster case that Vince and I worked on. As you know, Vince sells a game called Monsters and Mortals, and one of the arguments we made in the case was, why should Monster Energy have exclusive rights to use the term monster for a video game, especially when that video game might incorporate or include monsters as characters, right? I mean, why should Monster be the only one that gets to use the term monsters in the name of video game? When there are dozens, hundreds, thousands of other games that have monsters as characters in it, shouldn't they be able to use the term monster in their title for their video game? Probably. So that's the whole thing with trademarks is the more descriptive a trademark is of the product or service that you're providing, the less protection you're able to achieve, the less ability you have to enforce your trademark rights. And so, when you think about branding, it's often good to try to find either completely made up names. For example, the word Exxon or Xerox are completely coined, made up terms. Those are very, very strong trademarks. Or you want to think of using a name, an English language word that is a common word but doesn't apply to the actual product or service. So, example, apple, right? The word apple is a fruit, but it's used in connection with computers and mobile devices and other things that have nothing to do with the fruit. Very, very strong trademark. And is very very easily or can be the scope of protection is very broad, and so it can be enforced much more easily.
That's a great way to sum it up. I saw there's some law firm in South Africa that was writing up a thesis on why these corporations do not use common words to have a strong enforceable trademark after the incident with us in Monster Energy. So yeah, that's a good thing to keep in mind. Made up words are probably a lot better to use than common ones.
Yeah, I mean, there's nothing wrong with using a common term for a trademark. Apple is a very, very common term. The question is, what's the product or service that's being used with? If you're using the term phone, but it has nothing to do with phones, completely nothing. Like if you named a restaurant Phone, don't know why you would, but if you wanted to, then that would be a very strong trademark for a restaurant.
All right, so next up we have, what happens if I forget to trademark my game's name? Can another company force me to change my game's name if they file a trademark for the same name at a later date? So if they forget to file a trademark and then some other company files one for the same name 2 years down the road, can they force you to change the name of your game even though you came out first?
Yeah, well, I'm only going to talk about the United States because the answer to that question is going to vary depending what country you're in. But in the United States, the issue is who was using the name first, not who registered the name first. That's often not all that relevant. It can be relevant in certain situations, but generally, let's say you start selling a game on January 1st, and you don't do anything to try to register that name as a trademark in the United States, and then somebody else a year later files a trademark application for a very similar name or even identical name for related or similar or overlapping products and services. If that happens, then actually you as the prior user, as the first user, has the right to challenge that trademark application or challenge that trademark registration in the United States because you were first. So it is a very, very rare case, and in fact, it's so rare it's actually never even come up in my career, that the second user, the later user, can stop the first user from continuing to use their trademark for their product or service. It's a very rare case that would happen in.
Well, that's good to know. I'm sure that'll make some of them feel a little better because I've got a lot of fan developers, or not even fan developers, indie game developers that have told me or admitted that they never trademarked their game even though it's already released and out on the market on Steam or somewhere like that. So that's a little bit of reassurance for them, I guess, at least in the US.
Well, the fact of the matter is, when you walk down the street, walk down your local main street, walk down your local high street, you know, the vast majority of those names are not going to be registered as trademarks. If you're looking in the, if you're looking at if you're looking in Steam, if you're looking at, the PlayStation Store, whatever it might be, most of a large majority of those games are not going to have registered trademarks. It, and it's not because they shouldn't. It's not because it's not a good idea. It's because it's not on the top of people's minds. They want to create a game. They want to create a good experience. Probably registering the trademark is not like their number one priority. And so I want people to understand that it's, you know, even if you don't register your trademark right off the bat, that doesn't mean you don't have rights. You do have trademark rights. I think it's something to really strongly consider, especially if your game is very popular. People start making knockoffs or ripoffs, or even like just fan games. That's when you want to maybe start thinking about, okay, well, this got bigger than maybe I thought it was going to be. Maybe it's time to think about trying to register the trademark. I will say that one other thing is that delay in registering a trademark can cause issues, and it can become more expensive when you wait, because what if somebody already filed a trademark application for a similar name, for similar products or services? That could increase the costs and time to register your trademark, because you might have to challenge that other trademark, and that's expensive and can be very time consuming. So really the key is to register as early as possible. As soon as you kind of know that this is a name you want to use for your game or for your development company, that is when to start. That's when you should really optimally start looking into the availability of that name. And if it is available, then filing a trademark application to reserve it while you continue to develop the game.
No, that's great. That's really good to know for a lot of them. So that brings me to our last trademark question, which is the one we kind of discussed with each other earlier. Can they file a trademark before their game is ready to sell?
Absolutely. And in fact, that's the optimal way of doing it, because in the United States, and I think this is probably true for a lot of countries where you can file an application without any use. In the United States, there are actually a few ways to register a trademark, but for the purposes of this discussion, there are two ways to register a trademark. One is if your trademark is in use already, meaning you're already selling your product or service under the name or logo, whatever it might be. The second way is to file your trademark application on what we call an intent to use basis. And what's great about the intent to use system is that you can reserve your name, you can reserve your logo as of the filing date of the application. And that gives you time to develop the game, market the game, sell the game. And then once you've done that, then we can finalize the trademark application and the trademark registration will issue. The good news is that there isn't really any rush. In the United States, once you file an intent to use trademark application, you can basically hold that application open for about 4 years. I know it takes a lot of time to develop games. It might take 4 years. Who knows? I don't think that's unheard of, especially for very complex or very complicated games. So yes, you do have to pay fees to maintain the application and keep it alive, keep it open. But the good news is that all of your rights date back to the filing date of the trademark application. So even if it took you 4 years to get the registration, all of your rights date all the way back to the time you filed the application. So if there was an intervening use, let's say you find out, hey, someone on Steam released a game under the name that I filed a trademark application for. Once you get your trademark registration, you can go back and say, hey, you're infringing my mark because I filed a trademark application before you released your game. So that's the power of the intent to use system.
Yeah, the Dark Deception fans are well aware how long it takes to make a game, so that's really good to know. Those are all great trademark questions. I hope you all got something from that. Some of you have any questions regarding naming your game and how to protect your name. If you missed some of it, you can always go back after this live stream's over and kind of listen to what Morris said again and see if any of it pertains to questions that you have or when we do the live chat questions, you can ask any trademark related questions that you have as well. So without further ado, we're moving on to the copyright questions. So Tyler, I hope you're ready. Most of these are more copyright focused because of the fan game development community. So just to kick things off, the first question is, what is copyright infringement?
Well, this is a question I get asked a lot from creators. And before I start, I just wanted to remind everybody that this is not legal advice. Even though I represent a lot of creators, I do not represent you. And if you have a specific question around specific fact patterns, please reach out to an attorney and get legal advice directly. This is just for educational purposes. And a lot of it is from my knowledge and my opinion of how things might play out, when you have a copyright infringement. I actually prepared a specific answer for this because I wanted to get all the nuances in this. So I'm actually going to read this, right?
Oh, please.
So copyright infringement occurs when someone copies, distributes, performs, displays, or creates derivative works of a copyrighted work without the copyright owner's permission. And then this last part, I even hate to say it because we're going to open a huge can of worms here. Except in cases where an exception like fair use applies. So that's the answer. So it's when you take someone's IP without their permission. That's what copyright infringement is, right? Now, some people will say, well, that's fair use, right? Or they'll just slap fair use on it and they'll say it's fair use. And fair use is actually not a real thing. It's a defense that you use in litigation in front of a judge or jury. And you can still get sued, right? You take someone's IP, you can very easily be sued. Or if you're, on YouTube putting the content out, you'll get a copyright strike or claims, which is easier. But or you might get demonetized, or your channel just gets terminated if they put 3 strikes on you. So that's sort of the basic answer, and we can go into fair use if you want to, but let's go through the questions that you have, Vince.
Oh yeah, and Morris, I was going to tell you, this is going to go for a little while with the list. If you need to step away for any reason, you can just kind of mute your collab cam, and it's fine. It just turns a black screen, so you don't have to stay there the entire time. It's up to you until we get to the live chat. Just I got my tea. Maybe you want yours. So yeah, actually that's. Oh, sorry. Go ahead.
No, I appreciate it. Thank you, Vince.
Oh, no problem. And then back to Tyler, what she said. I see that a lot on YouTube where they will steal something or borrow it or use it. I don't know what their intention is, but they will often be a little confused and think that there's this blanket term, fair use, that protects them and allows them to use everything. And I see a lot of them don't really understand that term, what is fair use or how it applies, or if it even offers any protection. And like you said, that's not really a real thing. But I think there's a lot of confusion, and I'm sure you probably encounter that with your, maybe not your clients, but just in your profession dealing with content creators.
Sure.
And I start to see that with game developers too. So the next question we have is covers with fan games and copyrighted assets. So the question is, when making a fan game based on an existing copyrighted IP, are you able to use their game assets like audio and models without permission as long as the game is free?
So I think the reason why people get focused on the free aspect is because it's one of the elements of the fair use test, right? Fair use states that one of the prongs is if it's free, then it's more likely to be fair use. But it's actually doesn't really matter if you steal some. And I say steal, and I apologize. I'm being kind of harsh about stealing. But if you appropriate someone's IP without their permission, you don't need to pay somebody. By the way, you could just go to whoever the IP owner is and just get their permission. Yes, you can use assets, you can use the music, you can use the characters, or you can use whatever. Then you have their permission. They won't come after you. simply because it's free doesn't give you the rights to use it. If the IP holder comes back and says, well, I didn't give you permission, this is derivative of my original work, right? My ideas, my concepts, my characters, what I drew, my storyline, my music. And they can simply just say, you don't have permission. And they can go after you, whether it's a takedown notice, a cease and desist. Vince, do you know most of your audience here, when they're making, fan games, like, are they, where is it being distributed usually?
Largely, I've seen, and somebody said my audio was a little low in the stream, so I hope this is better. I'm getting like really close to my mic now. Let me know if you can hear me better. Most of our fan game developers tend to release on platforms like GameJolt, also itch.io, and it's like a couple of other like indie game markets that are mostly browser based, or they offer links to download their fan games. So I've seen GameJolt and itch.io is kind of like the popular two for fan game development. They're not able to list them on like Steam or console markets or things of that nature.
That's what I was wondering, was about Steam. So the question is, when there is a violation, right? How do the developers usually go after violators?
Well, my personal policy has been to keep it pretty open. I've told our fans that as long as they don't claim ownership of the assets, they don't try to monetize the assets, that I will allow them to make fan games for the Dark Deception community. But I've seen other developers, like there's a similar, or another indie developer named Bendy. Their team has kind of revised their position recently and become more open, but in the beginning they were filing DMCAs for every fan game that went up. I've seen like Five Nights at Freddy's. Scott Cawthon is very open. He allows fan games, but then you have somebody like Nintendo that strikes literally everything. So it's very mixed.
Right. And I do think the bigger companies tend to take a more strict corporate position, right? I had a client whose channel got stricken because he took music from a Sony game, and Sony just doesn't play. They just put 3 strikes. They delete, YouTube deleted his channel, and now we can't get Sony to basically, just even reply to us or interact with us. So I do think the bigger developers, tend to be a little more strict. So that's sort of my answer about, if it's free, it doesn't really matter. But like Morris said, it just depends sometimes. Like you just gave a perfect example, right? Like, you're okay with it sometimes, some other developers are okay, and then some are just not. I think sometimes you could do your own research and just see, right? Like, do these games typically take down and not allow it, or do they maybe allow it and you have a better chance of getting away with it?
I think the risk when you, at least the risk that I've witnessed and also experienced, is that when you allow the fan development community to openly create fan games, most of the time you're not going to have a problem. But eventually there's going to be a developer or two that starts to believe that those assets are theirs, and they forget where they got them from, and they start to feel a sense of ownership. And that's where these problems kind of come into play, and why we get these kind of questions.
Do you mean, can I clarify? So the original developer will take fan games and then use those assets? Is that what you're saying?
Yeah, so they might take audio or our designs or the gameplay mechanics, anything that's related to the game. Usually it's our designs and the audio that they use the most. So they will copy the design, the characters, the story, the audio, and they'll use it. And at some point, because it's different, they might start to feel that they have like theirs is so different that they technically own it. So we've had like issues with that. I've seen that issues play out in other communities similar to that also had fan games. It's just some people kind of lose the sense that this is a kind of borrowed assets or copyrighted material, and it can lead to problems or confusion. So that's one of the reasons we're making this video, is to put the educational or the information out there so people have a reference of what is okay and what's not. So there won't be, hopefully, I mean, there's always going to be confusion, but hopefully there'll be less. That's where your insight and knowledge, even as an educational approach, is greatly very valuable to our audience, and I think all the fan game audiences, not just for our game. So,
Well, I look, my goal is to always make the law feel less scary, because what I don't want is to prevent creators and creatives from creating, because that, I think that is so important and powerful, especially in the face of the, the flood of AI that's coming. I think storytelling and human-made uh, uh, art and games and videos and books and everything is very important. So I think it's really great to kind of destigmatize some of the fears around the legal. But I think, to your point about the fan games that go too far, or they forget, where the original IP came from, and then they feel like they own it. And then you, as someone who has, very generously given permission to use your assets, then you have to like maybe reel them back and say, wait, like I didn't say that you can now go make this whole new game and go sell it because you're basing everything off of my assets. So there's a real question of enforcement that happens. When I used to work at Disney, I don't know if people know this, but Disney doesn't actively go after violators.
oh, really?
Because well, imagine you'd have to employ millions of people to do that. Like the literally the amount of violations that would be happening. Now, the times when Disney does enforce it is if the work is negative or derogatory. So really think about that when you're using someone's work. Like someone's more likely to come after you if you're using it in a negative way. And if someone brought the violation to Disney's attention and it was like really egregious and they were making lots of money from it, and then Disney would step in and try to right the situation. So there is a question of violation, right? Like I know for a fact Nintendo has a very active division that
yes.
goes after violators. That's all they do, right? That's their sole job, is to go find violators on all levels, right? It's not just the video games, it's all IP. Pokemon is very much the same as well.
That actually, the next question is a really popular one that I hear a lot with regards to 3D rendered images. So the question is, if I data mine models from a company's game or somehow acquire them from somebody who data mined the 3D assets and then create rendered 3D images from those models, do I own those rendered 3D images?
Yeah, so this goes to derivative work, and I think people don't understand that the underlying models, they still remain the copyrighted IP of the original company. So even if you create new renders from them, you don't own the original work. It's still derived from someone else's original contents, original work. And again, it comes down to enforcement, but it also comes down to transformation, right? If it's so unrecognizable, and that's actually one of the tests of fair use, is it has been transformed so much that someone could argue it's original work, then again, it's like what Morris says, then it just depends, right? Like if the new creator can show that it cannot be recognized from the original work, then maybe it is now his original work. But if the original IP holder can say, no, you can totally see these elements and these details were so unique to our design that it's definitely ours. That's why a lot of times when you go to litigation, you make the judge or jury like, you put like drawings in front of them, you're like trying to like educate them and it comes down to reasonable person standard, right? Could a reasonable person determine that that is so different, it's no longer the original? Does that make sense?
Yeah, I've actually seen this story pop up numerous times regarding this, because I saw it with Naughty Dog, where they had a fan piece that, because the development teams now are so large and involve so many pieces and external studios and vendors, that when they source art for the game that they think is from the team, somehow fan art or fan renders get slipped in by an employee or one of the artists. Like they get confused because there's a lot of really good fan artists and fan renderers. They look very similar, so they can get mixed in, and then you get like a fan artist that goes online and claims the company stole their renders or stole their art. But it's basically made using that company's assets. So the company usually, in this, in an act of good faith, will apologize and remove it because they don't want to use fan renders or art. But legally, I don't think they're required to. If they wanted to use it, they could. It just, maybe it's not the optics that they want.
Sure, you're right. You don't want to be a company that's perceived as being a bully or taking a fan's art without their permission. But I think the developer would have a pretty good argument that this was based on their IP to begin with, and it's so similar that I do. I don't know if you have this, but I now that I'm thinking about it, I did represent this company that did they designed dice for a game, right? And so people could submit their dice, designs, and then that could become owned by the original company. But there was like terms of service that they had to sign that said, I'm going to give you permission now because I want you to display my dice so that it can be used by your community and in your games. So I'm giving you permission now to use my IP. So there is a workaround around that. And so I don't know how deep you guys go into with your terms of service in saying, well, you can make fan art based off of my IP, but anything you make is owned by me. Right. So that's work for hire language. And so if you as a developer has something in your language, when you could just bypass that, I guess, or make sure that's covered off. If you are a developer that wants to give fans the ability to make fan games off of their IP.
We actually do have that. We have like a legal disclaimer that says this is for fan purposes only. All assets and characters, blah, 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 remains property of Glowstick Entertainment, and I will not challenge that. And it's, if they post that at the beginning of their game, then we allow them to make the game. If they don't, we usually will remove it because they are potentially a risk for, conflict in the future. With the rendered images and art, it's a little harder. And I think the most recent example I've seen was with Poppy Playtime, where they had a character named Catnap that somebody made a 3D render of, and the artist at the studio didn't know it was a fan render, and they kind of traced over it and got the same pose to create some illustrated art for marketing. And the I guess the community recognized the rendered pose, so they made a stink about it. And somebody in the chat mentioned FNAF Help Wanted. I didn't see that one, but apparently it happens more and more often now. And the fans get really upset and they claim their work was stolen. But it's, it's legally, they're allowed to use it. It's based on their work. It's just, they would prefer not to. And it's no way to put a disclaimer on art, I don't think.
Well, I know. So that gets tricky, but I think if we were to go to court in that specific example that you said, I think the original developer who owns the IP would probably prevail because they do own the IP and but if you get some cases, you have a fan who has the deep pockets or the conviction to maybe take the developer to court, and if they could win, then you have precedent, right? That that leans the other way. But I just haven't really seen that. I think the courts tend to really protect the original IP holders and the original creators of the work.
I'm guessing here. I think that's why companies like Nintendo and Sony, besides wanting to control the image of their brand, I think they don't want to wind up in a situation where they have to take their fans to court. So
Yeah.
they'd rather just cut it off in the beginning and not even have to worry about that, versus by allowing our fans to do that. And I mean, I never want to have to take any of our fans to court. That's not,
Right.
I don't think that's anything any developer wants to do. But yeah, it can get, it can get dramatic online sometimes. So I understand now maybe why Sony and Nintendo does that. It's what is it, throwing a nuke at a nail? But
Yeah, I think you're probably right? Like they just don't even want to go down that road of having to, because when I used to be at the studios, and if we ever had an actor, violate something, a contract, we would never want it to be known as the studio that would sue an actor, right? So you never want to
yeah.
be known as the developer that sues a fan, because then no one would want to work with you, and you would lose, goodwill, and people would probably be less likely to support you or buy your games.
Well, this is kind of a follow-up to this question. The next one is, can I prevent other people from reusing the 3D rendered images without my permission? So if they make these rendered images, can they,
Yeah.
they feel like it belongs to them, can they, because I see that on X, Twitter, whatever they want to call it, I see a lot of times people demanding that other people ask their permission to use their rendered images, fan images, but it's based on
Yeah,
copyrighted IP.
I mean, it's unlikely that they can prevent people from reusing it just because they don't own the original copyright. I think the original rights holder can claim infringement. But again, it kind of goes back to what we were talking about, is just how original is this new rendering, right? Like how transformed has it been? If it's unrecognizable from the original art, then I think the new creator can claim, well, this is original art that I created. But if it's still recognizable from the original art, I think sure they can complain all they want, right? They can go on Twitter or Reddit or wherever, and complain and say stuff. But I think again, it's like, can they enforce it? Could they go to court and try to protect their rights? I don't think they can, because they don't own the original rights. The developer does.
No, it's often, all the scenarios that I've seen from different games is it's exactly the same model. They just put new lighting in.
Yeah.
So it's exactly the same. So
No, and then very unlikely that they can enforce anything, because they don't actually own anything.
no, so what I tell our fans, and I hope they can share with other people, is if you choose to do 3D rendered images, you have to understand, if you're reusing game assets from a game that's belongs to a company or an indie developer, it doesn't belong to you, that you are creating that for everybody. So anyone can use your work. They don't need to get your permission. That even includes the developer themselves. And I think that's something a lot of fans and fan developers don't understand. And
Right.
really, you shouldn't be creating these works to try to hold them or gatekeep them or have some ownership of them. I believe that the original intent is they want to create something to share with the community and add value to the community for everyone. So they should already kind of mentally prepare themselves that other people can post this, other people can throw this in their YouTube thumbnails. It's for everybody. It's public domain at that point, but it's still at the root belongs to the copyright holder. If they want to, they can DMCA every single image and have them all removed, because ultimately it's based on that. Correct me
I
if I'm
think that's
wrong.
right. No, I think that's right. But humans are very what's the word? Possessive of our creations, right? We think because we worked on it that it's ours, not really understanding that, well, no, this concept, this original art came from someone else's mind or a team of people, right? And and they worked for a developer and it's owned by the developer. And so I think this is a tricky area, with fan art and fan games.
Yeah, the next question, I think we kind of covered it there. It was what if the company itself reuses those rendered fan images without the fan creator's permission?
Like I said, because they own the original models, I think they have what we would call superior copyright rights. The new render, right, from the fan is likely doesn't give you an independent copyright claim over them. And to your point, if they're literally just changing lighting on it, I mean, that's not transformation, right? It's still the original work, and you can totally recognize it, as the developer's work. So I think the answer would be, that they don't need permission.
Yeah, I think most developers wouldn't want to use fan work just on the basis of they would consider it like inferior work. But a lot of fan developers now are actually highly skilled, and it can be harder to distinguish when you have a team of different studios across the world. So it's good to see that, because I see that not even with our own community, other communities, I constantly see creators and developers and content creators hurling "you stole my work" accusations at each other, especially like OCs, like original characters, but that's completely different. That's something they create themselves, but it may not be as original as they think it is. Like it could be kind of also stolen design, but just change one or two elements of it, and then they call it an original character. So
Yeah.
it's a lot of confusion about that. But hopefully this clarifies that for some of you, because I see a lot of people in the chat that do this kind of thing. And yeah, if you're going to continue to do it, I really think you should. A lot of you do great work. Just know that it's open for everyone to use, and you should be okay with that.
Right.
The next question is about data mined assets. So the question is, can I be sued if I data mine assets such as models or audio from a company's game and then share those assets online, either for free or for money?
Well, if the question is, can you be sued? The beauty and nightmare of living in the US is you can be sued for anything, right? The tricky part is getting yourself out of the lawsuit. But in data mining isn't always, itself isn't always illegal, but sharing extracted assets is a clear copyright violation. If it's free, it's a little better, but if you sell those assets, like you could potentially like face criminal copyright charges in extreme cases, right? Like I've heard of it, but it's rare. And some companies have sued individuals for this. So how often are you seeing this happening? That the data mining of assets happening?
Oh, we actually it's very frequent now, to the point where we have to actually plan for people data mining our releases to prevent them from being able to recover assets that we don't want them to have yet. I think the lawsuit side applies to a game that's still in development and assets get leaked. So like Grand Theft Auto 6, somebody steals models from within the company. I think what happened recently was with a content creator that they gave early access to, or somehow had access to their chat group, and he was able to leak assets.
Oh,
He didn't charge any money, he just dropped them for free online. Or it was either video or assets. So in that situation, could Rockstar go after him and sue him?
well, I think for sure. I mean, when you sue somebody, you have to be able to show damages, right? So in those types of situation where pirated content, for the lack of a better word, is released before the release of the game or movies, is taken very harshly by the studios or by the developers, because they are counting on the launch, right, to get a certain number of sales. Now, if it's just some assets are being, shared, I don't know how much, like how much of the game is being shown, right? Or it's like it ruins the surprise of the game for people. Like, I don't know that they could claim or that people are gonna not gonna buy it, right? They're probably still gonna buy the game because they want the game. But I think the companies to basically send a message to the world, right? Or to make an example of somebody might sue because they don't want people to do this. They don't want their games which haven't been released yet to be leaked to the world, right? Because that takes away from the unique and specialness of it when people usually wait for many years for a new game to come out.
Yeah, I don't think I've seen many instances where people are sued for data mining assets. I think it would be more for the instances where they try to monetize it in some way, and that that's a more clear example of theft.
Yeah, I mean, your question was, can they be sued, right? It wasn't how
Yes.
often did they get sued. So yes, the answer is yes, you could get sued, but the chances of it is rare, right? I mean,
Yeah.
creators ask me all the time on YouTube, well, how often do creators get sued for IP infringement? And it's actually pretty rare. You know what people usually get sued for is employment issues. I mean, like,
Really?
as a business owner, like, that's what you usually get sued for. Oh yeah. Most of my clients have issues around employment, right? Wrongful termination, harassment,
Oh,
discrimination,
yeah.
those types of things.
I guess that makes sense because they hire some editor
Yep.
contractor and there's some kind of dispute between them. I guess that makes a lot more sense. So yeah, I think only in extreme examples, and I haven't seen any. So I think the data mining's fine as long as you don't have any malicious intent for it or try to do something extreme. You should be okay. I don't mind that you
Mm-hmm.
data mine our assets. I just try to stop you all from getting stuff you shouldn't
Yeah.
see.
Mm-hmm.
So the next one we have is fan game ownership without copyrighted assets. So if they make a fan game based on an existing company's game and lore, but don't actually use any existing assets from their game and create all original assets from scratch, do they own that fan game?
Well, no. So the answer is no, right? Because even though the game assets might be yours, but the lore, the characters, the overall universe is still owned by the original, copyright holder, here, the developer. Because again, it goes back to the derivative work. Even though you created the derivative work, it still requires permission from the original copyright holder. So, and again, it goes back to what we were talking about, the transformation, the originality. Like, if the characters or the storyline or the setting, is recognizable to the the original game, then I think you don't have really a leg to stand on in arguing that, well, I own all that. Have you seen this play out at all, Vince, in real life?
Yeah, actually, I have. I've been asked that by several of our developers within the dark deception community, and I kind of told them the same thing. So we
Mm-hmm.
offered to kind of do a fanverse, like Five Nights at Freddy's has a fanverse where they officially publish fan games that want to monetize because they can't own the game. It's based on Five Nights at Freddy's. Even if it doesn't use the exact characters, it's based on the lore and it's existing within the universe. So Scott Cawthon with Five Nights at Freddy's offered to publish it so that they could exist and monetize. And we kind of do the same thing. Although we haven't officially kicked it off yet, I've had a couple teams making fan games for Dark Deception approach us and kind of ask about that and say, could we release this on our own even if you don't publish us? Like, could we put this game on Steam and make money if you give us, would you give us permission to do that? And I said, no, I would only give permission to a fan game that we publish officially. It has to be official. And you can't monetize it because it's still within Dark Deception. It would still have to be free because they did a really good job on it. They put a lot of work into it, and they're kind of at that point of investment of their time where they want to see a return on it, like a reward.
Sure.
And I understand that, and they want to make money off it. So I told them that's the best we could do is publish it, but they always have that question of, do I own this?
Right. And I think for the developer too, there must be, a consistency in design and quality, right? That you guys adhere to, right? As the developer, and not and from what you're saying, some of the fan games and are as good as what you guys would make, but it's still not, like someone might look at it and say, wait, but this isn't the developer's work, right? Like it just feels different. So if they're going out and putting it out on Steam themselves, like there's going to be confusion in the marketplace, right? I think that's probably the issue that you're thinking about, right?
Yeah, these ones in this situation, they have based it in our world, on our game. They're using the Dark Deception name. They
Right.
reference Dark Deception characters. I've kind of told them if they really want to do that and they don't, if the game for whatever reason isn't good enough to be published, but they still really want to release it and own it, then I told them, you need to make an original game, like abandon
Mm-hmm.
the Dark Deception universe, stop using our
Mm-hmm.
characters, make
Mm-hmm.
it an original game, and then you can release it, and you won't need my
Yeah.
permission.
Sure.
So it could be a clone of Dark Deception, but it can't be, set in Dark Deception. But so far, our fans want it to be in Dark Deception. They want to be published by us. So
Right.
That's just a question I get a lot from our fan developers, and I'm sure the other indie developers out there have had very similar questions thrown their way. It's
Right.
just, a very common one.
Mm-hmm.
So, okay. The next question is about selling an unlicensed fan game.
Mm-hmm.
And they asked, what are the legal consequences if I get caught selling an unlicensed fan game without permission from the game developer? Are there any consequences if I'm still a minor?
Okay. So, this is what we just talked about above. I mean, you could be sued, right, for copyright infringement, and be ordered to stop selling the game and pay damages. And damages means they could get an accounting from you of how much money you've made from the sale, and they could ask you to disgorge that, and they would get to keep that because it's based on their IP. The company might send a takedown notice or a cease and desist letter before taking legal action. That's usually what happens. I do that a lot first. Um, you know, most companies don't want to sue, right? It's so much cheaper to just resolve the situation without going to court. It's very, very expensive to sue someone. It's 5 to 6 figures very easily just to file the complaint and do the first round of depositions and discovery. If you've made a lot of money, if the game's made substantial money, like there could be some statutory damages, up to almost $150,000 per game. And this is where trademarking your game or your name, like most developers do, it attaches federal violations.
Is it?
And so
Sorry to
what's
interrupt
that?
you there. Just on that note, you said per game. Do they count? Is that kind of all encompassing for all platforms? So if they take that game and put it on 7 platforms, would it be 150,000 in damages for all of them or per platform?
I think it's all of them, but it's like if they made one work and then they made a derivative of that work, like
Okay.
like I'm thinking like a per work. But again, like I don't know, right? Like I don't know if it's would it be per platform? Um, I just don't know. I think ultimately it will be damages, right? Like, well, like how much did you make across all the platforms? And you're just going to disgorge that back to us because we own that. And the last part about being a minor, you're still legally liable, but your parents actually may be held financially responsible. So if there's a judgment against you, your parents might be on the hook for that, which would be terrible. But that happens sometimes.
That will definitely make your mom and dad or your parents angry because they probably
Yeah.
don't know what you've been up to, and then they're going to get, a scary letter from a lawyer or from a court seeking damages. I mean, if you like your family, just don't put them in that situation.
Well, I
It's not
mean,
worth it.
this also goes back to a little bit of, I know you didn't ask me to talk about this, but I talk about it all the time.
Oh,
Is, if
please.
if you have a small business and you're making any money, you should have an LLC. Like that protects your personal assets from being touched. So let's say you currently work, for a company, or you have a 401k, or you own a house, or you own, I don't know, watches and paintings or whatever. If you don't have an LLC and you get sued, then all those personal assets can get touched in a judgment. If you have an LLC specifically for your business, if you're specifically making, games, and making money from it, you should definitely get an LLC. And in some situations, you should get insurance, general liability, maybe media insurance, which is also known as errors and omissions. And pay your taxes. I think those are like kind of general, like as a small business, that's what you should be doing. But like in that example, which doesn't quite fit like with the minor, but let's say you are not a minor, but you are making money and you have, an LLC, then that will protect you. And potentially if you're a young adult, maybe still living at home, I don't know, and your parents are supporting you, like there could be like just some commingling of assets and stuff. Like you just don't want to get your parents' assets like touched with anything. So like just always have an LLC. It's a like, my office does them for like $500. It's really not that expensive or complicated. But most people don't even really think about it.
Yeah, I was gonna ask like I think they went up in price. Like they used to actually be even cheaper than that. They're pretty easy to set up. So
Yeah.
better to protect yourself if you're of age. At least if you're at least 18, go set up an LLC. It's actually
Right.
What's the wait time on an LLC to get it fully set
Oh,
up?
it's really quick. My office, we get it in a couple of days.
Oh wow,
In
that's
California,
nice.
at least. I don't know other states. Like I typically do California, but I mean I do all the states, but I live in California, so I tend to have clients in California.
Okay, this next question's a big one because I've seen already at least 4 people asking about it in the chat, which is the use of AI with AI generated voices. So
Right.
first question is, what if I data mine and use audio, parentheses without permission, from a game that is a SAG project, and the voice actors that I lifted the audio from are all SAG members? Will I face any additional consequences from SAG-AFTRA, which is a voice actors union?
Right. So yes, you could face additional consequences, legal risks under SAG-AFTRA's contracts, which protects their members, right? These voice actors from unauthorized use of their performances. And this is what last year's strikes, or actually no, I guess 2 years ago, right? 2023, the strikes from SAG and WGA were really honing down on the AI issue. If you remember, Scarlett Johansson last year, like she went after OpenAI. Do you remember this? Like when Altman went and created the voice of Chat GPT, right? And they decided to use her voice. And we know it was her voice because he went and asked her for permission first because of her, because she was in the movie Her, and he really like wanted that. And she said no, and he basically did it anyway. And he was like, well, I changed it a little bit, but it was so clearly her voice, right? Like, because Scarlett has such a unique voice and cadence to her talking.
Oh, yeah.
So she was able to get that taken down. And I think these like AI, the deep fakes, I mean, this actually, Scarlett was in the news yesterday, right? Like because of the whole Kanye Super Bowl, thing. Like
Oh yeah.
some people made some deep fake art of her basically flipping Kanye off, right? But she had to come out and say that wasn't me. I mean, I think there was a little tongue in cheek. She's like, yeah, I might have done that. Like she's kind of like, I support that, but that wasn't me, right? She didn't say I support that, but she didn't say that she didn't support it, but she just said that wasn't me. It was a deep fake. It was an AI rendered, stealing of my likeness. So SAG is very protective of its members. And they will come after people who are using their voices. And that's why actors join SAG, is because they have that extra protection, right? They have basically a union or guild, however you want to define them, backing them up when there's a violation.
Yeah, that's actually important because I have seen, well, in our case, Dark Deception is a SAG project, so is Monsters and Mortals. And I have seen people lifting like Tara Strong's voice and Carolyn Seymour's voice, who are pretty high-level voice actresses, and running it through AI to create their own custom lines.
Sure.
And I'm always kind of wondering, like, if SAG finds out about that, are they going to go after them directly, or are they going to come after me to go after them on their behalf? Like
probably both. I mean, they would just cover widely to make sure that the violation stops. If you're like, these are fan games that you are distributing on your end?
No, I'm not distributing it at all. I'm just wondering if somehow we're in that chain of responsibility simply because they took it from our game.
No. I don't think so. They wouldn't hold you responsible. But if you came around and somehow authorized it or used it, or like you said, because you said earlier, like if fan games are something that you guys distribute, or kind of codify, then yes, I think you could be in trouble for that.
Yeah, that is kind of, I think what made me fear that is because I told our fan base that it's okay to do fan games and use our audio, and I didn't think about the voice actor audio, which is the first thing they kind of all went after. But
well, you have to look at your agreement with the voice actors then, right? Like,
yeah,
do they I guess the question is going to be, because they sometimes have like residual rights or derivative works approval or money that they would make from that. So if there's money being made from it, I don't know, right? I have no idea what your contract with them.
and we once
Is
we
it upfront? It's just upfront voice acting, right? And that's it. There's no like residuals or royalties behind it.
Oh yeah, it's just the standard scales for SAG for
Okay.
us for our games. But once I kind of realized what the fans were using, I kind of clearly told them, the voice actor lines are off limits. You guys just do your own interpretations. Do some voice acting yourselves, make your own. And they did. I think our community was pretty good about that. They switched and started, doing their own interpretation of our characters' voices or doing original voices. So thankfully, we haven't had a problem with that. There's only been like maybe one or two people that continuously run it through AI for their fan games, but they never really finish their fan games, so it hasn't been a problem. It's just there's always that potential that it could become a problem with somebody in the near future.
Well, yeah, if an actor, says, well, no, I only gave you permission to use it for your game, not these derivative games, which might be different than your game, right? Like it's just that does become a slippery slope, I think.
Yeah, my position isn't like nobody has permission to use any of our voice actors' audio, and I've kind of stated that. So,
right.
But I've seen it's a problem in other games, and as long as AI keeps advancing as quickly as it has been, there's always going to be people that want to play around with it and see what they can do.
Right.
So it's really hard to control. And the SAG video game strike is still going. I think their longest strike. Our fans are waiting on that to end because it's blocking us from recording. But
yeah, I'm sorry. It is tough. Everything shuts down, right?
Definitely, yeah. So the next question after that, is that it for the AI? I think there's one more. Oh no, the next question is kind of what we already answered. It was just about if they use AI generated versions of the voices in their game, which you kind of covered, so I don't think we need to address that one. The next one
Okay.
is fan art and ownership rights,
Mm-hmm.
which is can they claim ownership of fan art if it's based on characters or images from an existing. I think we answered that one, didn't we? Ownership of fan art. Oh, this is not 3D rendered images. This is like a 2D illustration.
Mm-hmm.
So
Mm-hmm.
if I have a character in my game named Malik, if they do a painting of Malik, it's obviously Malik, but it's their own illustration, their own skill.
Right.
Can they claim ownership of that?
I think you can own the artwork itself. And I have a son, who's 14 and loves anime, and he's always drawing, right? Um, that's just his art, right? Like that he has in his sketchbook. I think you can claim, well, this is a unique artistic expression. But if you start selling it, right? Um, the original rights holder, could take action against you, but the likelihood of them doing that is probably not great. Um, but you can't prevent other people from reposting it if like the original copyright holder or company allows it. Does that make sense?
Yeah, I think what you said, because I've seen, a lot of people love anime and they go to those anime conventions and they go to the artist gallery and they do, unlicensed fan drawings of popular IP. That's pretty normal.
Sure.
As long as they don't, I think, make an image and put it on, I don't know, this is so unlikely, but if they did like an illustration of a popular character and put it up on Amazon or something and it sold, $1 million
Mm-hmm.
worth of revenue because people just
Mm-hmm.
love that illustration
Right.
so much, then maybe Sega or whoever owns that character might step in because they're making too much money.
Maybe. Like I said, I think something you do yourself that you're not selling. Again, that's always like the threshold, right? Like, are you selling and making money from it? Then that's when the original rights holder like will pop up their head and say, wait a minute, that's my IP. Why are you making money from it? Right? That's usually like the when it gets to be an issue for the developers or the original artists. So and like what if you, going back to my example about Disney, is like, what if you used it in a derogatory or negative way, right? Like you took their art and you did like racist things with it, or just like, just things that, like, do you know what I mean? You had the character say things that, they would
Yeah.
never say. Then I think the original artist or the developer will come down and stop that.
So I guess long story short, you do own your illustration. You just have to be aware that you own it, but you don't own it. If you do anything
Sort of.
that
Yeah.
angers the IP holder or, slights them in any way, or, if you're making too much money off it, they can always step in. It's just most of the time they won't because you're not making
Yeah. I mean,
millions of dollars and you're not putting something hateful or against their brand. They won't get
yeah,
involved.
I mean, my son draws. I think that is it the show or the game is called Arcane, and it's
Oh
like the
yeah.
main character is Victor. I think, I don't know. I'm trying to pay attention, and like he'll put it on his Instagram page, right? It's fine. Like people will be like, "Oh, this looks great," but like he's not selling it, so it's just like, "Hey, I drew something that I love," and I think that's fine, right? But I think it's when you start selling it or when you use it in a negative way that I think that's when problems start happening.
Okay, that's great because fan artists just, they're passionate. They just do it. They
Yes.
never ask permission from the rights holder. So that's
Right.
really good for them to know. And I see some people in the chat are responding to that. So that's a good bit of information for them.
Mm-hmm.
I think the next one involves music.
Mm-hmm.
So music. Okay, music cover ownership rights. So we have a lot of aspiring composers. They do their own covers of our music and other games' music.
Mm-hmm.
I don't know if this is your area of expertise, but they're saying if I create a cover or alternate version of a music track from an existing game, like a remix or something of that nature, without permission, do I still own it?
Well, no, you don't own it because the composition and the melody, right, are still copyrighted, and you would actually need a mechanical license to legally distribute a cover song. Um, and thank you for that small a note. Like, I'm not a music attorney, so like I can talk about this kind of basically. But if you have like really, really technical questions about music, you should probably reach out to a music attorney. Here's the thing, right? And I can talk about YouTube because that's my specialty. Music publishers will run their songs through the content ID system, right, on YouTube. And so anytime a song is covered, they immediately know it, right? Like I have a client, Andy Morris, who covers huge, huge songs. He's the kid, like in the cafeteria in the colleges, and he'll start playing, and then like people will just like stop because he's playing like Coldplay or like Imagine Dragons or One Republic, and like people just recognize the song. And he knows that every time he puts that song out, the publisher is going to claim 30 to 50% of his AdSense, and he's okay with that because he wants millions of views on his videos. And so I think you have to realize that music publishers, especially with games, are super, super strict about letting people use their music because it's so easy for them to sometimes find out about it. And sometimes they pay a lot of money for these composers to come in and compose the music to a film or to a game, right? And they want to protect that. So just because you cover it doesn't mean you own it.
Okay, so then the next question I have is like if they made a cover without permission and it became very popular on like YouTube, and then somebody else like reposted it without their permission and was trying to claim ownership of that cover, could they like copy strike that and claim any kind of ownership to have it removed?
The person doing the cover?
Yeah, so if somebody took a cover of, I don't know, a Taylor Swift song, and it's like a remix or some kind of very different version of an existing popular Taylor Swift song. It's a unique cover, but they didn't get permission from Taylor Swift. And somebody else just steals it and reposts it. Do they have any claim of ownership to have it removed?
No.
Okay.
Only Taylor does, or, her label.
So unless they've actually licensed or gotten permission to use that, they can't really.
Yes, and it really depends, and it really depends on what the license says, right? I mean, sometimes you could get a license to use it for a very specific event or thing, and you don't typically get to reproduce that and sell it, right?
Makes sense.
For instance, when I used to work in Hollywood, sometimes colleges would come to us asking for a license to show a film, right, to their students. But it would only be for that one day, that it was a very specific license on how you can use it. So you just have to see, but most of the time, IP holders are not going to give you, like Taylor Swift is probably not going to give you permission, to use her. Yeah, not for free. Yeah.
I actually got rejected for a song we were trying to get licensed, and because they didn't want it to be used in a horror game.
See, there's that too, right? And that's why, when you were talking about the voice actors, sometimes voice actors will have a provision or actors will have a provision in their agreement that says that, well, you can't, it's a one picture license. You can't use this in derivative, like subsequent sequels without my permission, because I don't know what that sequel is going to be like. So there's always a question of like, if you have a fan that makes a version of your game, like, does that storyline take a weird turn that, maybe the original voice actor wouldn't have agreed to if they have some sort of say in the storyline? Sometimes they'll ask for, the plot or the storyline, or I don't know, or even the script. If you give that much, you get huge actors who might have that, right? But yeah, it all comes down to what was the original work that it was going to be used for, and how much does that change.
Makes sense. And the next one we have coming up is a little bit more relevant. I get this one a lot. This is back to the fair use that we talked about earlier. So I guess this is just our chance to kind of elaborate on that a little bit more. How
Yeah.
is fair use legally defined and applied? That's our question.
Okay. So this is the 4-factor test that I mentioned, right? So fair use is a legal doctrine, right, that allows limited use of copyrighted material without permission, right, from the original rights holders for purposes like commentary. This could be like news, right? Or criticism, like a movie review, right? Like you see these movie review channels who can show big sections of a movie because they're doing criticism or commentary on it. It could be for educational or teaching purposes, right? A lot of teachers are able to use things, or schools are able to use things without permission, or research. And the 4 factors that the courts consider is, what's the purpose and character? Is the use transformative? Like, has it been transformed, adding new meaning to it, or is it commercial? Number 2 is the nature of the work, right? Factual works are more likely to be fair use versus fictional work. Number 3 is the amount, right? And how substantial is it? If it's very little, it's probably better. I mean, I say this to people, like creators on YouTube, under 5 seconds typically is okay. But the shorter it is, the better, because it won't get flagged with Content ID, or it's less likely to be a problem. An effect on the market, right? If you, like what we talked about, the negative derogatory use, if your use harms the original rights holders market, then that's not fair use. And so that's sort of like what courts think about. Again, like I said, this is something that gets decided in court, right? Like when you get sued and you try to say, but Your Honor, this was fair use. And then the judge will say, okay, well then let's look at this 4-factor test and see if it's actually fair use.
I'm kind of curious, for the effect on the market harms the original market. That could be like harms the brand image as well. So if like somebody took
Yes.
Hello Kitty without asking permission and made her into a serial killer and made it like
Yep.
extremely
Yep.
gory and violent, and she goes around killing people like
Exactly.
Michael Myers,
Mhm.
that would be a good
Mhm.
example.
Totally, because that's not who Hello Kitty is, right? Like, Hello
Exactly.
Kitty is like cute and adorable and like loving, and you just want to, like snuggle with her. And so that's but it's interesting, right? Because it's been transformed, right? Like to some degree. But that's you can be sure Sanrio is gonna come after them for that.
Absolutely.
Yeah.
Definitely, yeah.
Yeah.
Yeah, I remember we were at one point trying to, and we were doing this through proper channels, but we were trying to get Pac-Man, and they didn't want Pac-Man to look scary. So I can imagine if somebody just took Pac-Man and made him like shockingly horrifying or violent, it'd be kind of a similar thing. They're very protective of their brand images. So
Sure.
yeah, fair use would not cover you in that situation, no
Right.
matter how much commentary you put on it.
Right.
Let me see, is this a continuation or another question? Applying fair use to video games and fan games. Okay, that's what we just talked about. Do fan games ever qualify as fair use?
Sometimes, I mean, there are parody games, right? Like, and you know this better than I do, right? Like, but sometimes people make parodies of the games, right?
Oh, it's a good example. There's a Sonic the Hedgehog game that became very popular. It's a fan game. It was called Sonic.exe. and it was basically an unfair Sonic game where the entire game pretends to be a normal Sonic game, but it's actually this completely rigged demon version of Sonic the Hedgehog, and it just kills you unfairly at every chance it gets. He has like blood coming from his eyes. But it's supposed to be a parody. So would that
Did
be
they get
covered?
in trouble for that?
Not that I've
Do you
seen.
know?
I don't think Sega ever went after them. So
That's interesting.
could they
Because
have?
that's not how I would necessarily think of a parody, but
Yeah, where's the
but
line
that's a good
on parody versus
again, it's just like it depends, right? I mean, if you like you think of SNL, right? Like SNL makes parodies of celebrities all the time. And so it's like you're making fun basically. And so, you know, what were they making fun of Sonic the Hedgehog? Maybe, but again, like maybe I'd have to see it to kind of understand it a little bit. But it all just depends on like how extreme the transformation is. You know, I think there are situations where, let's say, you know, moving past parody, because again, it just depends, right? If somebody takes one of your games and like it makes educational content from it, right? Saying, well, look, this is how they did it, and this is how they draw, and this is how they develop the storyline, and more likely than not, like that could be deemed fair use. Now, you as the developer could totally go sue somebody because you own IP, but a court might find it to be protected by fair use because it's educational only, especially if they're like not making money from it. Again, that's always like the line, right? Like, are they making money from it? If they are making money from it, more likely than not, the court will say this is not fair use. You know, the example I gave about fan art, you know, like my son puts on Instagram, it's non-commercial, and if it's like highly transformed, like it's almost like kind of you can't even recognize the character, but you kind of see like it's like an arcane character, but it's like really different, then that's probably protected by fair use. So like there are also like mods, right? Like that, like maybe they make new levels or fan made patches for an existing game.
Yes.
I think maybe that might be okay, but have you had experiences with that?
Yeah, we actually, our game Monsters and Mortals has a very active mod community, and I've seen it on other PC games. It's a lot easier on PC due to the open nature of it. But they'll do things like create alternate character skins or modify environments and levels. Usually things of that nature, as long as they don't put anything hateful. I guess the problem is when they start to mod in copyrighted content from other games. Like they might take...
Yeah.
I can't use Disney as an example anymore because all their stuff's public domain mostly, but if they took Mario from Mario Brothers and changed one of our character skins to be Mario, I guess Nintendo could come after us because of that patch, or they would go after the fan that created it and insist that we remove it or block it from the game, something of that nature. That's my guess.
Yeah. Again, it's the distribution, right? If you're distributing copyrighted works that a fan made, right, or used, and you know for a fact that that's owned by somebody else, you would probably be on the hook because you're distributing it and allowing it in your game.
So whoever's distributing it is the one who's legally liable. Okay, so that definitely
if you're making money from it.
Yeah, that wouldn't be us, but the fans, I can't stop them. So that would not be fair use in that situation, or would it?
I don't think so, but it all comes down to, you know, are they going to come enforce it and do a takedown and say that you violated their rights? I mean, I guess like the sheer volume of people they would need to, you know, monitor and find the violations with a small mod. Like, it's just like, I think it's unlikely, but I can't say no, this will not happen, right? Because again, anybody can get in trouble or sued for anything.
I think they would probably, just like Disney, they would focus on the big offenders, maybe popular games, not everybody. Like you said, that's just too big of a haystack to go through. They would just, look at the nails that stick out.
Right.
Is there anything else with that question? Let me see. Okay, why fan games? Why do fan games often get shut down? So, companies like Nintendo or Sony file DMCA's.
Mm-hmm.
How come? Why are those DMCA's supported and acknowledged? It's just a harmless fan game.
Well, we've talked about this in some variation. They want to protect their IP. Maybe the fan art isn't consistent with their design or whatever they want out in the marketplace. Maybe they're planning on future sequels, remakes, or merchandise that might be similar to the fans' work, right? This is what you said, right? Sometimes when developers find out they accidentally pull in fan art or games, they immediately take it out because they just don't want the chance of a fan to say, well, like, I augmented your game, I made it so much better, you made all this money because of me. I mean, I think the chance of them prevailing is very slim, but like, maybe I've certainly have seen people sue studios who say, wait, that storyline in your movie was from my script I submitted to you guys 5 years ago, right? Like,
Yeah.
and so it's like, it's very tricky. So you actually like don't want to take in content from people who don't work for you, where you don't have that piece of paper that says your results and proceeds are owned by me. So that is, I think, what happens is why they don't want any part of it, and they just wanted to get it shut down. And they don't want any unofficial projects to harm their brand image. We gave real extreme examples with Hello Kitty, but it's like, maybe they make fan games that are just like, it changes their characters a little bit or changes their storyline from what what the original game was.
This is kind of shallow, but it's kind of true. Is like what you said with the quality not being as good as the original product. Like, I mean, there are good fan game developers, but a lot of them, the skill level is appropriate for a fan game developer, somebody who's young.
Sure.
They haven't, reached that professional level yet. But their fan game becomes popular, it starts to replace the images of the real game in Google search. So when people search your game, they'll see these mod images and think that's what your game looks like, but it's not.
Right.
It's from like a fan game, but they don't take the time to see that, and it can affect people's opinion of your game. So
Totally. I mean, yeah, for like, if I were to go, maybe now look at your games and want to go play it, and then I'm like, oh, but these like images are like not really high quality or high res. Like, what's that about? Is this what the game looks like? And it's not, right? Like, the game is very, very different, but you get these images, right? Which is not representative of your game or your brand. And so I think that's why fan games get taken down.
Yeah, that all makes sense. It's up to the developer if they're okay with that, or if they want to have complete control of their brand image. Obviously, Nintendo is the extreme of wanting absolute control versus somebody like us, a small indie dev that just kind of keeps it the Wild West, and we accept the risk that comes with that. But it definitely is a risk. You also, like you said, you get fans that see similarities between their fan work and the developer's work and start telling everybody their idea is stolen or something of that nature. So it can cause a lot of unnecessary drama. So a lot of the developers, especially big companies, they don't want to have any legal liability. They just close all of
Right.
those loopholes. So
Right.
that brings us to how to minimize. I'm going to go through this last one quick because I want to give them at least a few minutes to ask some questions
Okay.
to you and Morris. So how
Okay.
to minimize legal risk when making a fan game.
Yeah, so I think number one is get permission, right? Like just get permission from the rights holder, like you have given, right, to your community. It's much harder for the big developers to give permission. Don't use exact character names or assets or trademarks. We've talked about, if you make it a parody, or just transform it rather than a direct remake, I think that also protects you. Don't monetize the game. That protects you a little bit, but just because it's free doesn't mean it can't get shut down. Label it as an unofficial fan project. Make sure that it's very clear. This isn't from the developer because, to just avoid the confusion. And just realize that making fan content is always going to be legally risky unless you have explicit permission from the rights holder. Fair use is not a guarantee. It just depends, on the context and the interpretation. We've talked about this. Developers vary in enforcement. Some tolerate fan projects like you do, and others aggressively shut them down. And again, just the making money part. If you're selling unlicensed fan games or extracted assets, that's really risky, and that's usually when lawsuits happen, if they happen. Again, rare, but it can happen.
No, that's perfect. I think that covers everything, and I agree with all of that advice. I don't know what constitutes as permission, if it's simply like, hey Vince, can I make a fan game? And I say yes, or do they need like an actual contract or agreement with me or with the company?
Well, a license is always best, right? A license that states what the rights and what the usage is. But sometimes an email is fine, right? Like if you just give permission. Some courts do hold emails to be binding contracts now, not every state. But it's better than not having it at all.
Yeah, because if it's just my word, like if they come to me and say, can I make a game? And I say, sure. Later I could be like, yeah, you know what? Never mind. And still
You can
guarantee
always
it.
remove permission, by the way. You can always remove permission as the IP holder.
Exactly. So if you have a legal agreement with me,
Yeah.
like I say, yes, you can make a Dark Deception fan game and I want to publish it, and we have a publishing agreement,
Right.
then it's not so easy for me to pull the rug out from under you and kill your fan game. I mean, there may still be terms that allow me to do that, but
Especially if they pay you, right? If there's a consideration, if you pay somebody for license, that's always better.
oh, absolutely, like the minimum
Yeah.
guarantee. Most
Right.
game companies require that to license anything. So,
Sure.
but yeah, at this level with fan games, with fan versus, it's kind of a new thing. It's something that kind of emerged from the FNAF community, and it's kind of spreading to other communities. We'll see where it goes, but I think we've got about 10 minutes left. I want to give them a chance to ask some questions from the chat. I don't know if Morris can still hear us.
Yep,
I
I'm
have
here.
just
Oh,
I
there
just
he
have
is.
a few minutes. So I just have a few minutes, Vince. So if there are any questions for me, if it's okay, I take them first, and then Morris, if you're okay, staying a little later and
Sure.
answering any trademark questions.
No,
Thank you.
that's perfect. I was going to tell you,
Yeah.
like at the point where you need to go, just go
Okay.
ahead and mute your cam.
Okay.
And I will, in the stream, it will cut it off for both of you. So no worries. They won't be able to hear. So let me go through and look for the questions related to you, Tyler, first. And there's a lot of them here, so let me kind of get the low-hanging fruit first. Okay, this is kind of an easy one. It relates to what we said earlier. I don't know if I'm too far from my mic. It says, and it's from King Alex 105X. If I draw an original character and I don't trademark or copyright it, could someone else try to take it for themselves and copyright and trademark it?
Well, I can talk about it, and Morris, you can add into it. But I think it's copyright is oftentimes automatic. If you put out a YouTube video, there's a copyright protection when something is tangible and put into tangible form. I think having a copyright is better protection, right? Like having a trademark. But I think could a person trademark something out from under you? I think that's the question, right? And I think Morris, I'll let you take over and talk about the trademark of it all. Like if you can show, and you said this earlier, right? If you can show first use, to use, I think that's sometimes dispositive with courts. But I guess it just depends, right, on the facts. I don't know. Morris, why don't you jump in?
Well, the names of characters are not trademarks, generally speaking, unless the name of the character is also being used as a trademark for a product or a service. So if you name a character, XYZ, and this character is just a character in the game, the name of that character in the game is not a trademark. However, if you then call your game The Adventures of XYZ, then now that name is a trademark. It's the name of the game. So it depends on what is actually trying to be protected, and how you're using it is what makes it registrable and protectable as a trademark or not.
Okay, I think that's a pretty solid answer. Next question I have is also related to you, Tyler. This one's a video. So he says, this is from Debilis Pegas. Question: I have to do a video about Dark Deception, a parody that would be based around the game and other stuff. Do I risk anything if I do that? I ask because I know that parody content can have trouble on YouTube.
I'm sorry, what's the specific question?
It seems like the question is, if they make a parody of Dark Deception, a parody video, do they run any risk of it being copy striked and removed? Or does that fall under fair use?
Well, again, right, like fair use is not a real thing, right? So an IP holder could just strike it. And you're the IP holder, right? To be clear.
Yes.
Vince? Okay. So if you
instance.
if you want to go copyright strike this person, you could. And the interesting thing about YouTube is YouTube has a very hands-off approach to copyright violations. They just don't get involved anymore. They used to, I think, a few years ago, but now they allow very free copyright strikes to happen.
I noticed that.
And YouTube says to you and this fan art person, you guys go figure it out. And YouTube tends to take the side of the IP holder. They're just like, you say you own it, and maybe you have to prove it somehow. And they just let you do the strike. And if you're vindictive and you do 3 strikes because they have 3 videos with your asset, then the channel is going to be terminated unless the fan game person can prove somehow that they have your permission or they paid you, but they wouldn't be able to prove fair use, like with you. Do you know what I mean? Because you as the IP holder just have you basically have unilateral say that this is my IP and you don't have permission to use it. That's how YouTube handles it these days. If it was like a court thing, it'd be subjective to a judge doing the fair use test and figuring out if this was actually fair use.
Yeah, I think this is at a YouTube level. At least that's what I'm reading it, interpreting it as. And like you said, I've noticed that YouTube doesn't question our strikes anymore. We don't really strike many people unless they are doing some kind of egregious misuse of our content or theft. But we notice they don't really debate us anymore. They just take it down immediately.
Yep.
So yeah, they absolutely do side with the IP holder almost immediately. So be aware of that. If
Well,
your
I think
parodies,
if I can
I'll go for
so
it.
if I could say something, isn't that really because of the DMCA? I mean, basically, you file a, if you file a legit, I don't want to call it legit because a lot of these are not legit, but if you file a complaint that meets all legal requirements, statutory requirements, then essentially YouTube is required to take it down.
Yes.
And then it's up to the alleged infringer to file a counter notice, right? That's generally how the process works. That's how I've dealt with it in the past. Is that your understanding?
Yeah, I mean, this is opening up another bag of worms here, but I've seen
Mhm.
a lot of fake companies pretending to be IP holders. Like, we've had people notify us that some group was filing copyright strikes on our behalf that we don't even know who they are. So there is a lot of fraudulent claims or DMCAs on YouTube, and it's bad if they don't question any of them. But that's like a whole other
Well,
thing.
there is an appeals process, right? Like there is an appeals process where you can try to appeal to YouTube. But again, if you're a small channel, and this is just a sad fact, if you're a small channel, you just have a little less of a voice, right? Like I'm sure I don't know, Vince, if you have a YouTube manager, but like the bigger channels tend to have YouTube managers, and so then you actually have someone you can talk to about issues. But if you're a small channel, YouTube, it's hard to get an appeal through. I have so many clients who have come to me with their channels terminated right now, and they just couldn't get anywhere with YouTube or the appeals process. And so some YouTubers are hiring lawyers now to help them, and that's unfortunate.
Now, sadly, I am the manager of our YouTube channel. We keep it small. But
No, I mean YouTube actually assigns you a manager.
Oh,
Like it's
that.
yeah.
Yes, we do
So
have one. So I guess
okay,
we're
yeah,
maybe mid-sized channel. I don't know
yeah.
where we fall. I
No,
think we're
that's
pretty
great.
small.
I mean, because I have a client who has 100,000 and he doesn't have a manager, and so he has no way of getting in touch with YouTube, and so because I know people at YouTube, he's coming to me for help, but it's still like
Oh, I
difficult
see.
because that's the and I'll end with this as a tip, which I think is very helpful. If you have a YouTube channel, if you have various YouTube channels, please don't have it under one email address. Because what happened to one of my clients was he has 5 YouTube channels. One of them got stricken, but because they were all under one email account, all 5 got deleted.
Oh, wow.
So please have your YouTube channels on different email addresses and have your AdSense account on different email addresses. So that was like the biggest kind of case study that I have encountered in the last couple of weeks. I was like, oh my God, YouTubers need to know this because it's horrifying.
That sounds painful. I definitely think that's a great piece of advice. A lot of YouTubers, we have our own list of dark deception ambassadors, which are basically YouTubers, content creators. So if any of you are using the same email for multiple channels, please change that.
Yeah.
Take her advice. And just to finish off with one last question, this one's pretty straightforward. They said that this is from Key Dash, I'm making a game inside Rec Room. It's not Dark Deception, it's an original game. I want to know if I'm allowed to use all level themes in order, but everything else will be original, like the layout, monsters, puzzles, and story. Maybe, I don't know. My immediate answer to this would be, if everything's original, that's fine, but the themes, which I assume is the music, is still our property, then he's still going to have a problem if we have a problem with his fan game. I don't know if that's correct.
Well, this is not really a legal question, right? This is you as the IP holder, right? He's asking about your game, correct?
Yeah, he's asking
or no?
me,
Okay.
and then I'm
Yeah.
saying that's our music. It's still a copyright infringement. Do you agree
Yeah.
with that?
Sure. I mean, any use of your original assets is yours, right? And only you can give permission for somebody to use it. So if you're saying on this live stream that you do not give permission, then any use of that will be a violation of your rights.
Oh yeah, I mean, if he got our permission, I'm not gonna give it on a live stream. I'm just saying,
No,
at
no, I
this
know.
point, you might as well just make your own music. You're already going the original game route. Why even use our music? Just go all
Yeah.
the way. It's like why sabotage yourself? Like go to a music library or hire some aspiring composer that wants to work with you. Like you definitely don't need our music. You can do your own. It's
Yeah.
be creative.
Well, I really have to jump. It was a
Yes.
pleasure talking to you guys. I'm so late for my next meeting. I'm supposed to be somewhere in 10 minutes, but I appreciate the time. And Morris, it was really nice to meet you.
It's nice
I
meeting you
will
too.
talk to you guys soon. Okay.
All right. Thank you, Tyler. It was a pleasure
Thanks.
Thank you.
having you.
Okay. Bye.
Bye bye. Oh. Wrong one. Okay. So yeah, that's a hard 2 hours. You're free to go, Morris, unless you want to take another question. It's up
If
to
somebody
you.
has some trademark questions, I'd be happy to answer a couple.
Sure, let me look through. If anybody has any trademark questions, this is your last chance to get it answered. Otherwise, I'm gonna look through what's already been said. So just give me 1 minute. I'm scrolling up through all this chat. I think you kind of answered everything really well earlier, though. Most of their questions are just copyright related.
Yeah, I mean that's definitely much more of an issue when you're talking about game development is copyright and fair use and things like that. So yeah, I'm not surprised there aren't too many trademark questions, but certainly when it comes to the name of your game, the name of your development company, any logos you might use in association with your company or your games, those are all trademarks. They can all be protected, and again, it's not
Oh,
required. Federal trademark registration isn't required, but it does provide a lot of benefits and protections.
here's a good question. And it's not in our chat because I think everybody focused on asking me dark deception questions and copyright questions. But what if somebody's logo or icon or whatever they trademark is AI generated?
Well, I mean, this is brand new in the law. I mean, this is the problem, right? I mean, the law has not caught up with technology yet. I will say that the test is always, for a trademark, the test is always likelihood of confusion. So even if a logo is generated by AI and that logo is confusingly similar to another logo, and it's being used in connection with a similar, identical, or related product or service, that's going to be an issue.
Well, there you have it. Definitely just kind of avoid AI. I know some of you think it's really cool and it's fun to play with, but don't try to trademark it. There's just none of that's defined yet, and there's a lot of regulation coming. So just use your own creativity. If you're not a good artist, hire somebody or team up with somebody. Do it just go the traditional route.
The old-fashioned way.
Yeah, the old-fashioned way. That's
The old-fashioned way.
the way we all went. So it's harder, it takes longer, but it's so much more rewarding, and you actually will be able to trademark your work and not have an issue. So which in the long run will save you from a lot of trouble and problems. But that's pretty much it. Morris, I really appreciate you coming on and being part of the stream.
Thank you, Vince.
It's really great. This is the first time I've ever seen Morris on camera, but we've been working together for years. So it's a pretty cool moment, and it's awesome we get to do a live stream together. So yeah, his information is in the description. If any of you have any trademark issues that you need help with, Morris is the best guy to go to. His email and contact info is there. So is Tyler's. If you want to check out Tyler, if you are a content creator and you want to ask her or consult with her about copyright law and how it applies to your channel, both of their information is in the video. So don't be shy, be sure to reach out. But what time is it there, Morris?
It is 1:12 p.m.
Oh man, it's like
Central time.
It's like 3 a.m. here, so you got the whole
Man,
day
it's
ahead
time
of
for you to go to bed, Vince.
No, the tea is keeping me going. I've got like a few more questions to do after this, but you go enjoy your day.
All right,
I'll finish up
Appreciate
with the audience here.
All right, sounds good. You take care.
Have a good one, man.
Yeah, bye.
I'll talk to you soon.
Bye.
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 All right, so it's back to just me. I'm gonna take a short little break. I think my screensaver says 10 minutes. It's not gonna be 10 minutes. It's gonna be like 2 or 3. So if you all need to do a bathroom run, grab some snacks, whatever you need to do, you get about 3 or 4 minutes, and then I'll be back to ask or answer any questions you have about the stream. Legal questions. I'll take some of your dark deception questions, but I don't want to. This is not a dark deception Q&A. Like I have a different dark deception Q&A coming up towards the end of February that will be actually dark deception. This is like a fan game legal Q&A because of the drama that happened in January with the document from that guy. I'm not even going to talk about that person in that document because it's just nonsense. And this Q&A was kind of to answer those legal questions because a lot of people just don't know this information, and I think that leads to those kind of I guess like exchanges. It's not just our fandom. I've seen it in many fandoms like Poppy and FNAF and Uncharted. Like even with the AAA companies, they have to deal with this. So I think it's something that's really good for people to know, whether you're making a fan game or not. So you know exactly where you stand, what your rights are, what constitutes stealing, what you own, what you don't own, what's copyright infringement, what's fair use. These are all really important things to know. Even for me, like I do a lot of collaborations. I need to know this information or I might mess up and do something I'm not supposed to and get in trouble with my partners. So if you're a serious or aspiring game developer, kind of kicking off and, you know, getting your feet wet with fan games or mods, this is a really good time to kind of learn all this stuff. It will save you of so many problems down the road and help you stay out of trouble, because there's nothing fun about court or having a lawyer or a legal team chase after you. So I hope this was really helpful for you all. Or, sorry, helpful. Remember, it's 3 a.m. here. And I'll be back in about 3 minutes, so just kind of hang tight, and we'll wrap this up with a few fun questions. So let me go ahead and do this. Okay, I'm back. Just had to refill my tea. It's the only thing keeping me going now. So thank you for waiting. Oh yeah, I forgot I have that turned on. I was gonna say that, guys, this is not a normal Dark Deception Q&A. Nobody has to do any super chats, but I appreciate if you do, if you've already done it. But this is open to everybody. It's not member locked like our Q&As usually are. So if you have any questions, feel free to ask. I can do about 20 more minutes, which puts the stream at 2.5 hours before I've just got to call it a night. It's like that would be like 3:40 a.m. here. And I need my sleep or I'm not going to be able to work on chapter 5 tomorrow. So yeah, if you guys have any questions about the stream, I'm pretty open to anything right now. It can be about the stream, it can be about the document drama, it can be about Dark Deception. I don't care. It's whatever you want to ask. You get me for 20 minutes and I'm happy to answer. So feel free. I'm just going to kind of sip the tea while you guys type. But I'm really glad that you all enjoyed it. It seemed like some people just answered a lot of questions for them. And that was kind of what I was hoping for. So really glad to see that this was useful. And if you have any friends that are, even they're not in the Dark Deception community or they're not Dark Deception fans, but they're fan developers, feel free to pass this stream link along to them if it answers any of their questions for whatever fandom they're making games for. Especially one maybe where the developer's not as open as we are. They might run into these issues a little bit more often. So Pyro Shark, he did a super chat. Okay, thank you for the donation, Pyro Shark. Appreciate it. Says he's not coming back, is he? Also great stream, by the way. I came back. I said I'd only be gone a few minutes. I stuck to that. Why is that in the background? Oh, okay. I see why. Let me fix that. Okay, that was on the wrong layer. I was like, why are the super chat alerts all hiding behind the background? It's because they're on the wrong layer. So we have a 1-year anniversary for Nomias, who asked, do lawyers fart? I'm sure they do. Sitting in a chair all day is rough. Especially if you see the amount of coffee that lawyers consume. It's inevitable. So Mr. Mister says, Vince, are you still pursuing legal action on the person that made the document? So, regarding that, if you missed the drama from last January, one of the whole point of this live stream was that we had a fan developer that went online and made a bunch of accusations against me. And pretty much all of the accusations were nonsense, but because they had a lot of quoted or out of context screenshots, it got some reactions from a lot of people, and I kind of had to answer that. And there was like at the end, I said I was going to file a defamation lawsuit against him. Now, for anyone that doesn't know me very well, that's just a lot of hot air. There's really, this guy who did the document is 18. That's basically a kid. I know that's legally an adult, he's legally liable, but it's basically a kid. Whoever's 18 is usually not mature enough to be mentally an adult. And they certainly don't have income. And they don't, unless they're from some super rich family, they're not gonna have anything that you can seek damages for. So it's really not worth our effort to go after this person. I don't care if they know that. It was just basically just making them squirm in that moment. Like they didn't call my bluff. But no, we're not gonna chase after this guy. Instead, we're just gonna give people answers. And hopefully that will be enough to kind of put that to rest. I'm not ever gonna address it again, even if this guy waits until we drop, you know, every little new thing we do and waits till we're trending to drop that document again. You know, eventually people are going to know that it's a bunch of BS. So we'll just wait for that moment. We're busy. We're here to make games, not have internet fights. So no, we're not going to chase after this guy. It would be, he's over in Europe or some other country. It would be impossible to find out who he is without breaking a lot of ethical boundaries as far as like data collection. So it's not impossible to find out who this person is, but it's not like really what we want to do, like go that route. So no, we are, that's already in the past for us. We're fully focused on making games. That's what we're here for. Let's see. So since Malik, whoops, oh wait, that's a Dark Deception question. Let me get to those last. So, oh, Oxy said the plushie collection in the background is dope. Yeah, we're very proud of that. It's like it's a really cool plushie collection. I'm trying to get that jacket that I posted online where I can put them in the jacket and wear it around on like Halloween or something. That'd be pretty cool. Okay, King Alex 105. Oh yeah, my question was if you'd be able to make a Google Doc or something organizing all the question answers for easy reference or easy to find. Yes, actually I already have one. I'm trying to think of the best way to distribute that for reference. So I'm not really, I guess I can just share. Yeah, I'll just make it open to the public and share it with everybody online later today after I wake up. That's like a pretty easy way for you all to reference. I have all of Tyler's answers for copyright. I don't have Morris's in there yet, so I'd have to update it with his answers for the trademark side. But yeah, absolutely. I'm very happy to share that with the community and really like the entire gaming community, not just the Dark Deception community. It's like a free consultation. Let's see, Hitop says, is Nixon still working with you? Oh yeah, that was like another thing from that document, is that the guy took a 3-year-old little Twitter argument that Nixon and I had after Chapter 3 came out, because the way me and Nixon describe it is like a team that's in a sport game and somehow they mess up and lose the game, and they're kind of fighting with each other because they expected each other to do better. After Chapter 3 came out, it had a lot of game-breaking bugs, and we were kind of arguing about whose fault that was. You know, it's kind of idiotic, but at that moment, it was just a little spat, and then we kind of handled it offline. Internally, we kind of apologized to each other and moved on. And Nix and I are still working together 3 years later, and we have future games planned together. So, yeah, we're good. So I don't know why he was taking that and trying to make it sound like he left a lot of stuff out of context intentionally, trying to make it sound like a recent thing for the people who didn't witness that before. And really, it was never even a big deal. But people wanted it to be, so I don't know why. I guess that made it easy to believe if he put it out of context, that there was some kind of drama between us, but there's not. I mean, does that mean Nixon and I are going to work together forever? No, of course not. Nobody stays together. No team stays together forever. You know, teams have their run, and then they move on to different things. Bands are the same way. They have their run. Very few, like, kind of stick together for their entire career. At some point, he's going to want to make a game that I don't want to make, or I'm going to want to make a game that he doesn't want to make. It's just, that's kind of natural. But our agreement with each other is kind of like, as long as we both enjoy making the games that we're making, we'll keep working together. And right now, we still enjoy making the games that we make. He still gets to do his FNAF stuff, and he works with Dark Deception. He's got the best of both worlds. And for me, he does really good work with Dark Deception. I mean, we have a completely different team for Super Dark Deception. So Nixon's not even involved with that. His focus is entirely on Dark Deception and games like that. So hopefully that answers that question. And at some point, Nixon was gonna have to like come online and explain what I just explained himself, but he was really hoping he wouldn't have to, because it's just, I don't know, it's just so lame. It's too painful to have to go online and say such an obvious thing just to make Twitter happy. It's just, I don't know, it's stupid. We didn't really want to get to that point, so we're just kind of like, you know what, I'll explain this. I'm not going to drag Nixon onto the stream too. And he's in the middle of moving anyway, so he really doesn't have time for that. Let me see. Can somebody explain what is this drama? The whole reason I didn't really want to waste any time like referencing the drama, because it wasn't really ever a drama for our team. Like, it didn't hurt us at all. It didn't slow down our games. All it did was make a lot of noise on my Twitter, and it was from one guy. And by continuing to talk about it, we're giving that guy the attention he wants, and we don't really care to do that or have time for that. It's really not that important to us to address it. So I didn't want to make this stream about that. Just by giving educational information, it pretty much debunks his entire list, except for the makeshift thing, which is also just ridiculous. It shows that that guy doesn't know anything about makeshift, because I mean, at that point, it was basically just this big smear campaign. He's just trying to make everything sound as horrible as possible. For those that don't know, makeshift allows creators to buy up to 50 units of their plushie. Most creators buy their own plushie to give it to their family and friends, which is what we do as well. So he was trying to make it sound like some scandal, like, oh, I don't know how you rig a crowdfunding. If you rig a crowdfunding, it means you're losing money. You're spending your own money instead of people buying your plushie. Then you're going to go out of business. That doesn't make any sense. But he was trying to make it sound like some intentional scandal. We always buy about 20 to 40 units of every plushie that we sell. So these cool plushies back here, I will always buy, I've only bought one for 40, but we will usually buy 20 to 30 of each one. 10 of those I keep for myself. I give to my family and friends. I've got a lot of nephews and nieces. They go to them. I keep one for my own collection just because, you know, once these things are gone, they never come around again. That's it. They're a limited edition. And then the other 20 are usually reserved for charity streams. So when we do charity streams for OR, the Organization for Autism Research, I will give those away as kind of like high-level rewards for people that donate. And the whole point of that is to encourage and motivate people to donate more. So like, they're not paying for the plushie, they're donating more to the cause. That money goes 100% to OR. None of it goes into my pocket. I paid for the plushie out of my own money. So I am losing money on that plushie and giving it away for free for people to donate money to OR. So, I don't know. He was trying to make that sound awful. I really don't understand what his angle with that was, but people love to hear something sounds awful. So yeah, just by explaining the law and having a couple lawyers explain it, it debunks pretty much every claim he made in there. So I'm just gonna leave it at that. And CoolCat5G said, I wanted to ask this question. If a DD fan game developer were to put their fan game on Steam and still follow your rules when making a fan game, like making it free and so on, would it be allowed? I would honestly prefer, when they're going for something like Steam, which is a massive platform that has, 80 to 100 million plus people, I would like them to run their game by me and get permission first, because that's a step up from smaller platforms like GameJolt. There's the possibility that it could cause confusion, especially if they name it Dark Deception. So if people will search for Dark Deception on Steam and it's going to come up into our game, they're going to think it's something that our team made. or that it's associated with us. So that one actually would be kind of a problem. We just have to check it out first and then make sure it, doesn't cause any problems, it's not going to cause confusion, and it doesn't misrepresent the Dark Deception brand. And if it's really good, that's something that would be considered for being published by our team. But it would have to kind of clear all those, check marks in order for us not to have it removed from Steam. And that's just to protect the Dark Deception brand. Because if people flood, Dark Deception fan games onto Steam, that could cause a lot of problems for Dark Deception searchability. And then people new to Dark Deception might get confused and think, the fan games are Dark Deception. Hey dude, this is not related, but I'll answer it anyways. Hey dude, have you ever watched Scott Pilgrim vs. the World? Yes, I own it. It's a great movie. At least I think it is. Haha Fun Spiders says, will the Roblox, Minecraft, and Fortnite games all have different stories, or would they all be the same? Actually, they all have their own unique story, so they are not the same. And they were all kind of crafted specifically for the platform they're on. So the Roblox Dark Deception game is made to, fully take advantage of what Roblox can do, and same for Fortnite and Minecraft. Landon Boys threw in 2. Thank you, Landon. I was telling you guys not to do super chats, but you're doing it anyway, so. Is a story with Dark Deception elements in it okay? Well, it depends on the context. What do you mean by is it okay? Is it okay to exist, or is it okay to sell and monetize? So, if it has Dark Deception elements, so if this is supposed to be, I think the way I'm interpreting this is this is supposed to be an original game, but it has Dark Deception elements, like running around and collecting shards. At that point, it would be called a clone. Clones are okay, as long as you're not using Dark Deception names, Dark Deception designs, Dark Deception story elements. Look how many games emerged from Doom. It formed the entire first-person shooter genre, and we have amazing technically they're clones, but they're evolved clones to the point of being original, like Call of Duty, Battlefield, even indie games like Dusk. So, clones are the way the genre moves forward. So yeah, there's going to be, and there's already been a couple Dark Deception clones that have been released for Steam. I think there was one that was called like Escape from Naraka or something like that. So a clone is okay. It's as long as it doesn't have anything that relates to Dark Deception. Having similar mechanics is fine. It's just, I don't want to hear Malik talking in the game. Then it would be a fan game. Once you put something Dark Deception in it, it becomes a fan game. And then you can't monetize it or try to have ownership of it. Key Dash. Hey Vince, remember the question about me making an original game and asking for level themes? I meant level themes in order by hotel, school, and the others in order, but everything is original. Oh, so you mean you're going to reproduce the exact levels, like the themes, like this is a hotel level. That's kind of sketchy, because then if we wanted to, and I'm not going to use us specifically, like any developer, if you completely copy the level structure of their game, then that constitutes some form of copyright infringement. You could be liable. Just being 100% honest with you, because then there's this very strong and clear similarity. If you have a hotel level in your game and a school level, that in itself is not bad. You should mix them up differently. I would put it that way. But if every single level is an exact copy of a Dark Deception level, like not exact copy, but like the same theme, then it would basically be almost the same game. So then there might be some grounds to claim plagiarism or copyright infringement. it kind of like muddies it a bit. Versus if you only have like a school and a hotel and then you have some original levels mixed in that are not in Dark Deception, then you don't have to worry. Let's see. Capybara Gamer said, will the chapter... Well, this is a Dark Deception question, but I'll take it. Will the Chapter 5 Teaser 1 be like the Chapter 5 ones? Will we have a second teaser? How does the SAG strike affect Chapter 5? Is WW gameplay unique like BB? Oh, Wicked Ways. Okay. Chapter 5 teaser be like the Chapter 5 ones? Well, I mean, there's only one teaser. We haven't released anything for Chapter 5 yet. And this will be... The first teaser is not going to be... I think a lot of people don't understand the difference between teaser and trailer. So a teaser is not going to give away a lot. It's just a glimpse. So usually teasers are cinematic. They're not gameplay trailers. So the gameplay trailer comes when the game releases. The first teaser is going to be cinematic. It's more of a hint of the Dark Deception story in Chapter 5. So it's going to be your first look at characters, at hints of elements in the story, but it's not going to give away anything huge or big or clearly show everything. It's just like a short glimpse, and we may do a few teasers between now and the release of Chapter 5, and we'll save like the big trailers. Obviously, we want to save them for the end when the game's ready to actually drop. We don't want to put those out too early and then completely fizzle out the hype train. And is Wicked Ways unique? Yes, Wicked Ways is... I mean, all the levels in Chapter 5 are very unique. They're not similar to any level in Dark Deception. Let's see. Pro Gamer. Hi, Vince. Hope you're... Or you threw in 10 euros. Thank you, Pro Gamer. Hi, Vince. Hope you're doing well. The malicious doc mentioned about you funding your own plushies through an account named Monkey King 2018. Even if that is true, is that really against Mayship's terms of service? I'll answer that one again because I already did. No, absolutely not. Like, I don't understand why that guy... Well, I understand why he did it. He's just trying to make everything sound terrible. But he obviously didn't read Makeship's terms of service. Makeship is the one that allows us to buy the plushies. They even give us a discount code. We get a manufacturer's discount on those plushies. So Makeship not only sells it to us, they give it to us at a discount. So when we buy the plushie, it's for our own use. It's intended so that we can do that for giveaways. That's another one I forgot to mention. So whenever I do plushies, I always do a giveaway. I do a giveaway to our VIP server, and I do a giveaway on our social media channels like Twitter. So we buy those plushies from Makeship to give them away. They don't just give it to us for free. We have to buy them. So of course, Monkey King 2018 is my purchase account for Makeship. But we're only allowed to buy 50 max. They won't allow us to buy more than that. And I never use the max. I only buy 20 to 40. And I think he was trying to imply that all of our campaigns would fail unless I bought those plushies, which is just absolute BS. Like, we've had one campaign, I think it was the Clown Gremlin, where that actually needed my purchases to succeed. And then who cares? It's like 160 people got the plushie they wanted because I pushed it over the edge with the manufacturer's purchase. All the others were so far above the minimum, it didn't matter. They didn't need my purchases. So that was what he was trying to push, was that somehow buying plushies for autistic charity streams and family members was dishonest. Yeah, pretty much every Makeship plushie partner buys their own plushie. That's... Like, I don't understand why people bought into that narrative. Mr. Mister threw in another 20. Thank you, Mr. Mister. Thank you for doing the stream. I think this will be useful to a lot of people. One more thing about the doc. What happened after the game jam? What happened to the prizes, if any, for the other developer, the FNF creator? Okay, so the fan game jam that we did is the only thing in that doc that is actually truthful. That's the only thing in that entire document that I actually have to say I've messed up and I'm at fault. So we ran a fan game jam that I shouldn't have run because I've never run a fan game jam before. Didn't know what I was doing. And we had 3 winners. And unfortunately, 2 of the winners were toxic. So after they won, we were going to offer them to put their game into Dark Deception Chapter 5 as part of the arcade. So some of you have seen the arcade in Super Dark Deception. It plays mini games. So we were going to make the prize. There was no cash award or anything like that offered. The prize was that their game would be put into Dark Deception Chapter 5 as one of those playable arcade mini games. Now, unfortunately, with any contest, the terms of service are if you do anything damaging to the event holder or the company behind the game jam, they have the right to terminate your award. They can pull the rug out, and that's what we did. 2 of them were spreading like malicious comments about us online. It was sent to me, I saw it, and I pulled the rug on 2 of them. The Five Nights, or the Friday Night Funkin' Game Jam winner was a winner, but we didn't have a prize for him because we can't put somebody else's copyrighted game into our game. We don't own the FNF brand. We don't have permission from them. We couldn't put it into our game with Chapter 5. So the only ones that could actually be added were the creators of, what is it, Pizza Time with Murder Monkeys, and then the guy who actually wrote that document, his game. And then those 2 were basically talked themselves out of their winning. So I was left with no option for the winners, and it was pretty much the game jam just died. And I've never done another game jam since, simply for that reason. So that's the only one I have to admit to the community that I screwed up, was that game jam. Let me see. Capybara Gamer threw another 5 reals. What is the unknown portal? Is it part of Fear Fortress, or is it its own thing? How hardware demanding is Chapter 5 compared to other games like Poppy Playtime? Great stream. Well, I'm not going to say anything about the unknown portal, and it is its own thing, but it's also part of a level, and I'm not going to say which level, because that's obviously spoiler territory. And how hardware demanding is Chapter 5? You know, Unreal Engine 5 is an upgrade, and it does increase the demand on your video card. We are trying to optimize it more to make it run, but it's not, you know, I'm not going to lie or, you know, blow smoke or anything of that nature. You know, it's not going to run on these old potato PCs. It's just not. UE5 is an extremely demanding engine that has nothing to do with how much we optimize our game. The engine itself is demanding. So I think pretty sure, you know, all of the consoles we're porting to don't have a problem with it. So I always advise people, if your PC can't handle it, just get the console version. And I mean, hopefully you don't have some hatred against consoles. It's the easier way to play it, really. I mean, Dark Deception works great with a controller. So if for some reason your PC is really old and you can't update it, rather than screaming about optimization, just go play the console version. It's great on PS5. It's great on Xbox Series SX. I would recommend both of those. Even Switch 2. I haven't really seen Dark Deception running on Switch 2 dev kit yet, but I will eventually, and if it runs as good as PS4 Pro, which is what people have kind of been saying, then it should run really well on there as well. Let's see. King Alex says, I feel it's better to do a contest for just art in game so you don't have such a small sample size. An issue with the game jam. Yeah, I think that's ultimately what kind of killed the game jam, is it was too small of a sample size, and we wound up with people that weren't the best people. And as you can see, it kind of proved me right, the document this guy is writing and how malicious he was. That's not somebody I want our game associated with, and I definitely didn't want him to be in our game. And that feeling, that kind of red flag turned out to be true, and I'm really glad that we cut him off, because this was a guy that was already kind of kicked out of our VIP server for abusing people and doing a hate campaign against a previous member. So he'd already kind of shown this behavior in the past, and we gave him the chance to kind of, or I gave him the chance to kind of turn over a new leaf, and he didn't, and I kind of got that vibe for him, and I just didn't want their game inside of our game and have this guy associated, because I knew it's gonna not work out well. So I think what we were doing previously was the smart way, just the art gallery. I think we've always had a lot of success with that. We have a lot of fans that are able to contribute with that. You don't need to know programming. You just have to love to make art. And we have all different degrees of skill level with art. It's more about the creativity and the interpretation than anything else. So I think I really enjoy the art gallery and being able to showcase our fans' talent that way. I think that's just the way we're gonna go again. I'm not gonna ever do another game jam. It's too hard to predict the winners, and they're not always actually even fans. So I prefer to like reward and stick with the people that really love Dark Deception and create beautiful works of art. We're just gonna stay with that, and it's a lot simpler. Let me see, I'm just looking through the chat right now, so apologies if you sent a super chat and I haven't addressed it yet. I'll get to it. I think I got most of the major ones. I have one more from Capybara Gamer, who threw in another 2 reals. Thank you. Which levels are getting gameplay changes in Enhanced Plus? I mean, right now, every level's been changed visually. Mascot Mayhem has the most significant update, just because that's the one I got the most feedback from fans as far as what it was missing and what it should have had and how it could be improved. Especially after they played that game, what was it, that fan game, Animatronic Atrocity. So we listened to fans on some things. We couldn't address everything. You know, it's impossible to squeeze in every fan suggestion. But we did listen to our community and put in as many of the things that people thought were missing as we could. I think one that was really addressed or suggested to us a lot was a longer introduction with the Joy Joy gang when you first walk into Zone 1. Like, that initial introduction behind the window is too brief. They wanted to see kind of more of an entrance into Joy Joy Land to make it feel more significant. So we agreed with that. We did that. We've also kind of altered the look a little bit. We answered some questions like, why didn't the castle blow up? Why did Doug not get past Joy Kill? We've kind of filled in a lot of blanks and added a lot more details. We've also extended the Joy Kill fight. So we made the Joy Kill fight a little more exciting. A lot of people told us that Zone 3 is too small. We made it a lot bigger. So things like that. The other levels are mostly visual improvements and lighting improvements. Well, I guess that's part of visual. So we've improved the models. A lot of things were very low poly before because it was built in UE4, which wasn't as powerful. So we've improved the geometry of the level a lot, added new lighting. Like the hotel, we've completely changed all of those wooden arches and the baseboards in the hallways. It makes it look a lot better. Stuff of that nature. Some of the ugly rooms from Elementary Evil we've redone. I think the entrance and that room where Malik kind of walks by were kind of simple and ugly before. We've made them a lot nicer. So stuff like that. Enhanced is exactly what it says, Enhanced Plus. I mean, we're not naming it that. That's just kind of like the unofficial thing we all call it. It's just Dark Deception, but yeah, this is the final version, and we've improved every level. Kindug, Capybara Gamer through another two. Kindug, sue Malik for attempting. Oh, sorry, am I reading that right? For attempting murder. Oh yeah, I mean, he could if they were in the normal world, but they're in the Nightmare Realms where Malik's kind of in charge and he makes the rules, so I don't think anyone's going to hear Doug's lawsuit. Although there are probably a lot of lawyers in hell, we'll see. All right, I think it's coming up on 2 hours and 50 minutes and my throat's kind of wearing out. So I'm gonna let you all go now before this turns into a Dark Deception Q&A, which it's not supposed to be. I'll see you all at the actual Dark Deception Q&A in a couple weeks. I'll do it before the end of February. I'll set that up pretty soon. I just gotta find out my schedule for the next 2 weeks so I don't have to change the date. But thank you all for sticking around with me this long and checking out the stream. I hope it was informative and answered whatever questions you have about fan game development or the document or Dark Deception, whatever you're here for. I hope it answered it. So you all have a good night, good day, wherever you are. I'm gonna go crash.